In Canada, there's both federal and provincial legislation that protects your personal information and gives you access to information that government organizations have about you. At the federal level, there are several pieces of legislation related to information protection and access. The Privacy Act, the Access to Information Act, the Personal Information Protection and Electronic Documents Act, or PEPITA. Now, the Privacy Act of 1983 extended existing laws that protect the personal information about individuals held by federal government institutions, and it provides access for individuals to the information held about them. It also restricts the kinds of information that government institutions can collect. For example, it states that no personal information shall be collected by a government institution unless it relates directly to an operating program or activity of the institution. It also restricts how information can be used. For example, government institutions are not allowed to use the information for purposes other than the information for which it was compiled or originally collected. You will notice on your income tax form, for example, that it asks you for permission to share your information with Elections Canada. The Privacy Act also gives individuals the right to access the information about themselves held by government institutions. The Access to Information Act of 1985 is different. It gives citizens and organizations the right to access other government-held information that is not about themselves. This is based on the principle that government information should be available to the public. This is the legislation that would enable you to access, for example, a government spending report. There are exceptions to the access to information, including access that might interfere with government operations or responsibilities, reveal personal information of others or information of third parties, or information restricted by statute. A third piece of federal legislation has wide sweeping application. This is the Personal Information Protection and Electronic Documents Act, called PEPITA, which was enacted in 2000. It was enacted in response to changing technology, which has resulted in the capture and movement of large amounts of personal information. PEPITA does not apply to government institutions which are already covered by the Privacy Act. It applies to every organization that collects, uses, or discloses personal information as part of its commercial activities. For example, PEPITA would govern information collected by an online dating company or by a department store. It does not apply to provincial government departments or provincial crown corporations. The provinces of British Columbia, Alberta, and Quebec have substantially similar provincial legislation, and organizations that are governed by provincial legislation are not subject to PEPITA within that province. But PEPITA still applies to information collected, used, or disclosed as part of federal work or outside the province. In Ontario, New Brunswick, and Newfoundland and Labrador, there's also similar legislation, but only in the area of health records. A good source of information about PEPITA and the Privacy Act is the website of the Privacy Commissioner of Canada.